Parles-tu français? Hablas español? Parli italiano? If you've used Babbel, you would. Babbel's conversation-based techniques teaches you useful words and phrases to get you speaking quickly about the things you actually talk about in the real world. With lessons handcrafted by over 200 language experts and voiced by real native speakers, Babbel is like having a private tutor in your pocket. Start speaking with Babbel today. Get up to 55% off your Babbel subscription right now at babbel.com/Wondery. Spelled BABBEL.com/Wondery. Rules and restrictions may apply.
I earned my degree online at Arizona State University. I chose to get my degree at ASU because I knew that I'd get a quality education, they were recognized for excellence, and that I would be prepared for the workforce upon graduating. To be associated with ASU, both as a student and alum, it makes me extremely proud, and having experienced the program, I know now that I'm set up for success. Learn more at asuonline.asu.edu.
This seems not hard to grasp, but also Alabama's Governor Kay Ivey is super racist.
Yeah, I'm not going to speak to what's in that woman's heart. I will say that she couldn't do it by herself, right? This is what the legislature keeps enacting.
True.
Welcome to Law and Chaos, where Ed Martin is out and Janine Pirro is in. God help us. We've got election cases, we've got impoundment cases, we've got immigration cases, we've got a lot to cover. So let's get after it. Happy Friday, Chaos Monkeys. I'm Liz Dye, and with me as always is Andrew Torres. Andrew, how are you?
Hey, Liz, I'm great. There is white smoke billowing out from over my apartment, and, that means something, I have been assured. So,
yeah, I guess it means that Ed Martin is the new pope.
Well, he's not going to be the U.S. attorney for the District of Columbia, and you're too modest for this. So this is a huge, Liz was right. You have been covering this guy from the jump. You said he was too crazy for even this Senate to confirm. And I took the under, right? I said, a Senate that confirms Russian asset, Tulsi Gabbard, brainworm, poisoned Robert F. Kennedy Jr., and Pam Bondi, whom, I would not trust to guess my weight, right? Like, I thought there was no chance they would draw the line on anyone, but I was wrong. You were right. So take a little victory lap, and why don't you tell us all about the bullet we just dodged?
Okay, first of all, I don't think that I have clairvoyant powers here.
I do.
I look, he had 120 days to get confirmed or get out, right? That was how long. That's how long somebody can sit in the position as an interim appointee. The Judiciary Committee had not scheduled his hearing, and we're getting to 120 days. I think May 20th would have been 120 days. And if he wasn't on the schedule for next week, it clearly wasn't going to happen. And then Tom Tillis said he was a no. Tom Tillis is a North Carolina senator. He's on the Judiciary Committee. And if he was a no, then this guy wasn't going to get out of committee. So I don't think that I have any special predictive powers, but I will agree with you. This was a huge bullet dodged. You have a January 6th protester who's never tried a case, or certainly never tried any criminal case. He, all he's done since he's been in the interim position is send nasty letters to Wikipedia and to the New England Journal of Medicine and to Chuck Schumer and Georgetown Law School and to medical marijuana providers and people who publish the names of the Doge Bros, right? He is, however, just been spectacularly incompetent. He's tried to wield the U.S. Attorney's Office in D.C. to enact political revenge for Donald Trump. He's threatened firms, he's threatened Special Counsel Jack Smith. He threatened Covington and Burling for, I think, giving Smith a little bit of pro bono time. He forgot to mention in his Senate paperwork that he showed up more than 150 times on Russia Today, which is the Kremlin's propaganda network.
That fits in with this administration.
Yeah, I think, look, from a math perspective, I think Murkowski would have been a pretty clear no. I suspect Mitch McConnell would have been a no. McConnell has voted against several nominees who have January 6th stink on him. And if Tillis is a no, that means probably that Collins was also a no. I think the writing was on the wall there.
Yeah, I think you're right, but but I am wary of the aphorism, be careful what you wish for because you might get it. So who's going to take his spot as interim U.S. attorney for the District of Columbia?
That would be Judge Janine Pirro, Judge Boxwine of Fox News. I mean, okay, she was
Cecily
a
Strong
judge
from Saturday Night Live. Yeah.
Yeah, I feel like she had to resign because her husband got into some shit and it was inappropriate for a judge to be married to a criminal. That's her ex-husband. He was actually pardoned in the last hour of Trump's presidency, the last time around. Albert Pirro was pardoned. And now she's going to be the U.S. attorney for D.C., which is very fun. I mean, she's a lucrative host. She can just rant and say stupid shit on Fox and live in New York, where, now she's got to move to D.C. and do scut work. But
she could be attorney general then.
Yeah, sure. So, okay, but Ed Martin is not gone. He will now be an associate deputy attorney general, and he will be a pardon attorney. That is, he will advise Trump on who to pardon. The previous occupant of the job was fired because
everybody he cares about has already been pardoned.
I know. Liz Oyer, who had this job before, she was fired because she said that it was not appropriate to give Mel Gibson his gun rights back because he's a domestic abuser. And anyway, he's got him. Pam Bondi made it happen. And
yes, she did.
Yeah. And Martin will be heading up the so-called Weaponization Working Group, which is tasked with reviewing the Justice Department's work during the Biden administration, including, of course, the investigations of Donald Trump, the special counsel investigation. So I guess he's going to do locker-ups to Jack Smith.
Can't wait. We live in the dumbest possible time.
Absolutely. Okay, let us get to docket alert. Dun dun.
Docket alert!
Hey, can I start with something silly?
I mean, something else silly besides Judge Janine?
Very fair. Look, I get it. I'm the impossibly hidebound traditionalist on the show, but
you're the older one.
Ouch. I do not get law firms that want to brand and market themselves they're a new flavor of yogurt, right? And apparently, I'm not the only one. So this is about Jacob Perrone. He is a personal injury lawyer from East Lansing, Michigan. He just filed a Section 1983 civil rights complaint on behalf of his client in federal court in front of federal judge Robert Jonker. That has been assigned to magistrate judge Ray Kent. And we're not going to talk about that case at all because before it could proceed, Judge Kent sua sponte issued this order. It says, order striking complaint. Each page of plaintiff's complaint appears on an e-filing, which is dominated by a large, multicolored cartoon dragon dressed in a suit, presumably because she is represented by the law firm of, quote, Dragon Lawyers PC, copyright award-winning lawyers, end quote. I will link to the docket in the show notes. I think it is not possible for me to express over the air how delightfully silly this watermark is.
Looking at it. Holy God.
It is not just a purple human form dragon in a suit on all 12 pages of this complaint. It's also a tiny little purple dragon head in the lower right-hand corner of each page with the footer with the page number. It's the signature block that has random text in purple font. It's that his phone number is 844 Jake Law. It's the wacky fonts and the sizes. And you know what? I started the segment as a bit of a curmudgeon, but I think maybe I've been sold on sharing a little purple joy in the drab world of pleadings. But
no.
Well, you and Judge Kent don't see it.
No, I mean, it would be great for me since my job is to read pleadings all goddamn day long and they're also depressing.
Right. So, imagine little teeny tiny dragon logo in the corner. Okay. Anyway, Judge Kent says, Federal Rule of Civil Procedure 12F1 allows a court to strike from a pleading or an insufficient defense or any redundant, immaterial, impertinent, or scandalous matter. Use of this dragon cartoon logo is not only distracting, it is juvenile and impertinent. The court is not a cartoon. Accordingly, it is ordered that the plaintiff's complaint is stricken. Plaintiff is directed to file an amended complaint containing the same allegations as the original complaint without the cartoon dragon by no later than May 5th. It is further ordered that plaintiff shall not file any other documents with the cartoon dragon or other inappropriate content. And, Jake Law did. And now There's a boring, old, normal complaint with almost no color in it.
Every party has a pooper. No, but thank you for explaining this to me. I saw it pass by me on Law Sky, which is where all the dorks, that hang out. And I was like, no, I do not have time to figure that one out. I got like 50 Trump TROs to read. Not one of them has a dragon. So thanks for that.
Yeah.
And speaking of Trump TROs, can we talk for a minute about what it means that the DC Circuit stayed itself in the middle of the night last night? Because that is not normal. I mean, it's not as not normal as the Supreme Court issuing a stay at 1 a.m. a couple of weeks ago, but it is weird as hell.
It's up there. I totally agree.
Okay, so the backdrop here is the U.S. Agency for Global Media Cases. That's the parent agency for the Voice of America and Radio Free Europe, Radio Liberty, and Middle East Broadcasting, and the other sister media agencies. We've talked and written about this a ton, so we're not going to get too weedsy on the backstory. But those are the agencies created by Congress, funded by Congress, with a statutory mandate to disseminate accurate, reliable news. Trump instead issued an executive order decreeing that they should be shut down, and he put Kari Lake in charge of USAGM to make it happen, which she did. She bigfooted in, she fired all the contractors and employees, she put on pre-recorded music, and she announced that the government would be getting for free news content from One America News, the conservative news network, so shitty that it's basically off of cable at this point.
Which is... We do not have time to get into all the ways in which that's illegal, but no, you cannot, as a for-profit entity, start giving stuff away to the government for free because of the whole, the first taste is free problem with your local drug dealer, right? There are laws against this. Again, Trump administration, not huge on following the law. And also, I have to say, right, you read the statute that the Voice of America and these other agencies, networks are supposed to be disseminating accurate, reliable news. This was created as an instrument of American soft power during the Cold War to combat the propaganda coming out of the Iron Curtain. And the Trump administration has burned down a century of effective American soft power in a month. So great job there.
Yeah. So Judge Royce Lamberth, who is an old school conservative on the federal bench in D.C., issued a preliminary injunction ordering Lake to put everything back and give the agencies their congressional allocation. We wrote about it at the blog. It was a great order. He just ripped the administration for ignoring both the International Broadcasting Act and the budget bill, which is, again, a law. But then the government appealed, and Judge Lamberth's order got stayed by the emergency panel at the D.C. Circuit.
Yeah, I don't want to go all ancient aliens here. I've done the math, but this is the third hell panel in a row at the D.C. Circuit handling emergency motions. It is Judges Gregory Katsas and Naomi Rao, two Trump appointees, and Cornelia Pillard, an Obama appointee, were the April panel. Remember, the D.C. Circuit emergency panel sits for an entire month. February was Justin Walker, Karen LaCraft Henderson, both conservatives, and Patricia Millett in dissent. So the May panel is Henderson, Judge Justin Walker, and Michelle Childs, a Biden appointee who is going to write a lot of angry dissents over the next 4 weeks. There are only 4 conservatives on the D.C. Circuit, and the wheel keeps kicking up 2 of them for 3 on the emergency panel, with disastrous effect. So anyway, that special panel, Katsas and Rao, stayed Judge Lamberth's order and let Kari Lake just dismember Voice of America and Radio Free Europe, Radio Liberty, and the other media networks. And their theory of the case was ridiculous, right? You can go back and listen to last Friday's show, episode 129. But basically, they say that all the impoundment cases where the government doesn't want to disperse funds are actually secretly contract disputes being, gussied up as if they were Administrative Procedure Act cases. That's not correct at all. But once a court has embraced that theory, that means that those claims have to go through this oddball court of federal claims. It's an Article 1 court under a law called the Tucker Act, rather than being handled in a normal Article 3 district court by a federal judge. And because the Court of Federal Claims is not an Article 3 court, it's a creation of Congress. That's what Article 1 means. That means that its powers are very limited. It cannot issue equitable relief. It cannot order prospective retroactive relief, and it is not equipped to handle thousands of claims from the grant recipients that Trump is burning to the ground, as well as, various states that Trump has, shut off the spigot of funds. So this is functionally no relief at all. It is a disaster. Now, there's a whole line of cases that say these types of complaints should not be heard in the Court of Federal Claims under the Tucker Act.
Yeah, I mean, just can I break in? Because I know I said this the other day, but the existence of any impoundment cases disproves this argument. Like the Supreme Court cases has said multiple times, the president has to disperse funds allocated by Congress. Those cases exist. I mean, everyone cites to this 1975 Supreme Court decision in Train v. City of New York. And you see, you've got City of New York in the caption. You can be pretty sure that the justices in 1975 didn't think that the grantees had to go to the Court of Federal Claims to get their money.
Yeah, well, you are talking about a functional Supreme Court as opposed to the Roberts Court, which starts at the result that it wants and then works backward and tries to cobble some excuse to get there. So 5 weeks ago, on the shadow docket, in a case called Department of Education versus California, the Supreme Court's conservatives said that a trial court in Massachusetts probably didn't have jurisdiction to order the Department of Education to disperse teacher funding because of the Tucker Act. They said it was actually a contract dispute, which, again, clearly it is not. It is a challenge to the Trump administration's policies gutting various agencies. But the Supreme Court said that the federal government would be irreparably harmed because they wouldn't be able to get the money back if they paid it out.
I hate that one, too. I mean, I think that's really
you should.
Just as dangerous as the Tucker Act, Court of Federal Claims stuff, right? Like this, the money doesn't belong to Donald Trump. It doesn't even belong to the Department of Education. It belongs to the grant recipient, right? The government is just a pass-through. It's not like a small business that has to pay its bills. And so if it pays money to the grant recipients as dictated by Congress, it's like not going to be able to, afford rent or something. I mean, and moreover, it violates the Anti-Deficiency Act for the government not to spend money when Congress tells it to. So this line of thinking, like the government's going to be harmed if it has to give federal grantees their money, is just bonkers, right? Like if the budget says $144 million annually is allocated for Radio Free Europe, Radio Liberty, and the Trump administration fails to spend it, that itself violates the law.
Yeah, and again, spending money is the definition. It's literally the textbook definition of reparable harm, right? The idea that you've had to allocate funds that are, a fraction of a percent of the federal budget could possibly be construed as irreparable harm is crazy. And as you said, the Train versus City of New York and every other decision in those line of impoundment cases, those precedents clearly indicate that these are not Tucker Act contract claims, right? But the terrible emergency panel was like, cool, we get what the plan is for these impoundment cases. Thanks for telling us which strand of spaghetti on the wall we're supposed to stick with. And so Katsas and Rao stayed Judge Lamberth's order on the theory that Voice of America's dispute was really a contract claim, and the government would be irreparably harmed by having to pay out the, I think, $12 million congressional allocation for April.
Yeah.
Yeah. But as we said, there are only 4 conservative judges out of 11 on the D.C. circuit. And so the broadcast networks appealed for en banc review by the entire court, and they got it at 12:40 a.m. Wednesday night. The full 11-judge bench stayed the Katsas-Rao order in its entirety. And thank God, because that was a death warrant for all of the networks. Some would be gone in a week. Most of the rest of them would be gone in a month without this order, which is why it happened this fast. But, I think this is really going to be important on a bunch of different levels.
Yeah, I agree with you. First of all 4 conservative judges dissented, right, together, Katsas, Rao, Walker, and Henderson. Although I guess if you're parsing it, Judge Henderson didn't join on Judge Katsas's Tucker Act analysis, but she did sign on to Judge Rao's hand-wringing about the government being irreparably injured by having to dispense congressionally allocated funds. Yeah. So what we know from this is that for the rest of May, while Henderson and Walker are on the emergency panel, they're going to rule in favor of the government in every one of the impoundment cases. Like Judge Henderson is occasionally rational, but she's not going to be in this instance. The second thing we know for sure is that the other 7 judges on the D.C. circuit do not agree and are willing to step in quickly. So I think we're going to see a lot more en banc appeals during the pendants, during May when we have yet another hell panel. Third, I suspect that this Tucker Act nonsense is going to be the dodge conservatives use to get around the impoundment problem. I mean, assuming they don't come to their senses, because that'll be a disaster for the Republic. But if they decide to give Trump what he wants, this is the way they're going to slice the salami. They're going to say, well, you have a remedy. It's just not a real remedy.
Right. I think you are exactly right on all three of those points. And I think the last one that you just articulated is the most important. I guess if you're looking for a silver lining, I should note that Chief Justice Roberts, he did not sign on to the shadow docket order in Department of Education versus California. It was 5-4. He didn't sign on to the dissents either. Keeping his powder dry, maybe to try and pull Justice Barrett along to save the Republic. Am I too much of an optimist here, Liz?
I really don't know. I mean, Justice Barrett does a lot of terrible shit, but she is sometimes not down to do 100% of the terrible shit conservatives would like her to do. I mean, that's why they've all, the conservatives have gone after her as a DEI hire or some shit like that.
Yeah.
Okay, we're going to take a little ad break and we will be right back. Unless you're a subscriber, patreon.com/lawandchaospod or lawandchaospod.com, in which case you will not be going to an ad break. Not today, not ever. Hang on, guys. And we're back. Okay, we have a bunch of immigration cases to talk about today, as per usual, every day from here on out, I guess. And look, these cases are important, both because these are human beings whose lives are being destroyed by a feckless, lawless administration, and because this is a preview of what this administration intends to do to U.S. citizens if they can get away with it. Look, here's a clip of the president saying due process doesn't matter if it's inconvenient.
Because the courts have all of a sudden, out of nowhere, they said, maybe you have to have trials. We're going to have 5 million trials. Doesn't work. You wouldn't have a country left. But hopefully the Supreme Court will save it. But what they've done is a very, very serious thing.
Well, that was terrible. And FBI Director Kash Patel echoed that under questioning by the Senate today. He said he does not know if non-citizens are entitled to due process under the Constitution, which of course they're entitled to due process. That's settled law. And it's apparent from the plain language of the document that says no person shall be deprived of rights without due process. It doesn't say no citizen shall be deprived. It says no person. So, okay, we've talked a lot about the case of Kilmar Abrego Garcia, the Maryland man whom the Trump administration renditioned to that gulag in El Salvador, despite an immigration judge's order saying that was the one country where the government definitely could not send him. And that's because Abrego Garcia fled El Salvador for the U.S. when he was 16, and a court found it credible that if he were to be returned, he would be targeted by MS-13 and could be tortured or killed. So the Trump administration did not care, sent him there anyway. And even though the Supreme Court ordered the administration to facilitate his return, the government has flatly refused to do anything to make that happen. So that case is playing out before Judge Paula Exinis of the U.S. District Court of the District of Maryland. But as it turns out, there is a second judge in the same court in Maryland who has made the same demand on the Trump administration. And that's Judge Stephanie Gallagher, a Trump appointee.
Yeah, we have mentioned her before. I should say, for full disclosure, that Judge Gallagher is someone I know well. We went to law school together. We've served on boards together. And I have deliberately not asked recently. But as of 2015, I know that she identified as a Republican. She was initially nominated to the federal bench by Obama, languished in limbo thanks to Mitch McConnell, and then was reappointed by Trump. So, she is not a Trump appointee at all. She is absolutely brilliant. She is hugely respected on the bench. And, Donald Trump will never, ever nominate anyone like her ever again. Now, merits. This is another astonishing case. The plaintiffs in this case stem back from 2019. They are UACs, unaccompanied alien children at the border. And so in July of 2019, those plaintiffs brought a class action complaint against the Department of Homeland Security. And throughout the first Trump administration and then the Biden administration's Department of Homeland Security, the parties litigated and then negotiated over how to treat children at the border who show up without their parents. In 2024, the plaintiffs and the Department of Homeland Security reached a voluntary settlement agreement. That agreement resulted in the dismissal of the litigation, and among other things, the agreement defined the class of plaintiffs that were entitled to relief. It is anyone who came to this country as an unaccompanied alien child who has filed an application for asylum to remain in the United States and who is now over 18 or has a parent or legal guardian in the United States and for which their asylum application remains pending. And the settlement, all it says, all right, it doesn't promise that they can stay in this country. It says that ICE will not deport any member of that class until the U.S. Customs and Immigration Services reaches what is called a final determination on the merits of their asylum application. That requires due process.
Right. And that settlement was approved by Judge Gallagher on November 25th, 2024. And unlike executive orders, an incoming administration can't just say, like, no, we're not going to follow settlements entered into by the last guy, because settlements are legally binding upon the government, not least because the plaintiffs agreed to drop their lawsuit in exchange for the protections of the settlement. Mm-hmm. But on March 15th, Trump issued that Illegal Alien Enemies Act proclamation, which applies to anyone over 14 years of age. And the administration took the ridiculous position that anyone subject to the AEA proclamation is by definition not a member of the unaccompanied minor class, which they agreed not to deport. I mean, this is the same logic that they used with Abrego Garcia, right? They said, right, well, you're in Tren de Aragua, so the order that says you can't be deported doesn't count anymore, which is not a thing.
No.
So at least one member of the class certified by Judge Gallagher, he is now 20, he's proceeding under the pseudonym Christian, was renditioned to that hellhole in El Salvador while his asylum claim was still pending. So Judge Gallagher was pissed. She first granted a TRO, and then on April 23rd, she granted a motion to enforce the settlement order, which is, with the class, that, among other things, required the administration to facilitate Christian's return to the United States.
And the administration has not facilitated Christian's return to the United States. Instead, after almost 2 weeks of not facilitating his return, this past Sunday, they filed a motion to vacate Part 2 of Judge Gallagher's order, which is the part ordering the facilitation of Christian's return. But we didn't know that that's what the administration did, not at first, because they filed that motion under seal. Their goal was for it not to be available on the public docket and visible to you and me, Liz. I'm not, not us specifically, but people like us.
Probably you. Not so much me. No, I'm kidding. So Judge Gallagher did not agree to keep this document under seal. The next day, she mostly unsealed the government's order and attachment. She only redacted the personal identifying information about Christian, which was, the disingenuous reason the government gave for not wanting to file this motion publicly. So now it's available on Pacer, and we have read it. And look, I mean, it's not hard to see why the Trump administration doesn't want this getting out, because here's what they did. First, they had the U.S. Customs and Immigration Service dummy up something they called an indicative asylum decision.
Yeah. So an indicative ruling is kind of a Civ Pro corner case. So, my walk-up song again. It happens when you ask a court to make a hypothetical ruling. And if, you're singing the Schoolhouse Rock song and you're like, wait a minute, courts have to have, live cases or controversy. Like, the way in which this corner case comes about is typically when you have an injunction that a district court has issued, and that's on appeal. And then the appellate court is sort of struggling with how to apply that injunction. So because it's on appeal, the district court, the trial court, doesn't have jurisdiction any longer. So it cannot issue a binding ruling. So what happens is the parties might ask that trial court to give an indicative ruling, right? If you had jurisdiction, Judge so-and-so, how would you construe your own injunction? And then the appellate court can take that indicative ruling and they do whatever they want with it, right? Like it's just an advisory opinion. So TLDR, indicative means hypothetical.
Right. So here's the thing that neither one of us has been able to figure out. It is clearly stated in the class certification ruling that members of the class must file for asylum. And it is equally clear in Judge Gallagher's April 23rd and May 5th orders that Christian has applied for asylum. But that is not the indicative ruling which the government submitted to this, supposed arbiter and attached to its motion. Instead, the indicative ruling treats Christian as if he is ineligible to apply for asylum, even though he has indeed applied for asylum and was certainly eligible.
Right. So the reason that the government has submitted this indicative hypothetical ruling, even though there's a pending actual application, is because the government wanted to get a particular answer, right? And indeed, that indicative ruling says, evidence indicates that the applicant would be subject to terrorism-related inadmissibility grounds and therefore inadmissible as an alien who is a member of a designated terrorist organization, Tren de Aragua. And then the indicative ruling cites to Marco Rubio designating Tren de Aragua as a terrorist organization and Trump's proclamation. But
but the portion of the decision outlining the actual evidence that Christian is really a member of TDA is redacted. Those redactions, I would note, are less than 5 lines long. Maybe it's 2 sentences. So whatever's under there is like less than robust, right? And no court has ever determined that Christian is a member of TDA. And remember, this guy came here as a baby or a child, right? He was a minor when he arrived. That's how he got into this class. He was a child arrival. So they are deporting a guy who's been here since he was a kid based on a wholly specious finding that he's actually a gang member. Like, please, that's the same shit they tried again with Abrego Garcia. So the government's argument is, look, we said this guy's a member of TDA, so it's foolish to make us facilitate his return, because if we did, USCIS would just reject his asylum application anyway on the grounds that he's a terrorist.
Right. So here's what the motion that the government tried to hide under seal says. USCIS has now determined Christian is not eligible for that discretionary asylum-based relief that is the subject of the settlement, nor does it make sense to order defendants, right, the Trump administration, to facilitate his return to allow for adjudication of his asylum application because USCIS has determined that he should not be returned to the U.S. He is barred from a grant of asylum and does not warrant an asylum grant in the exercise of discretion. Christian's case is moot. Christian has already received the precise relief sought in the motion to enforce the settlement agreement. USCIS adjudication on the merits and denial of that relief means he has no purpose being in the United States. And none of that is true on any level, right? This is, as the clip you played shows, Liz, the Trump administration saying in court that due process doesn't matter, right? Because the settlement gives Christian, as we read, the right to a final determination on his asylum application. And the most important factor in an affirmative application for asylum is for the asylum officer to evaluate the refugee's own testimony and determine whether they have a credible fear of future persecution if they're deported. Christian has not gotten to give that. That's how asylum cases get decided. And even if he had, and even if the asylum officer would have ruled against it, which we don't know, Christian would have a right to appeal a negative determination to an immigration judge and raise asylum as a defense to being deported. Now, look, I don't want to be naive or, Pollyanna about the process, right? Because it's not great. It needs to be fixed in the other direction. The immigration courts aren't great. The judges are Article 1, and they're often very hostile to asylum seekers. But the basic principle is that you at least have the legal right to have someone other than the administration that wants to deport you make the decision as to whether you're going to be tortured before they can deport you. What the Trump administration has done here is ask itself, hey, don't you agree this guy is a member of Tren de Aragua? Why, yes, I do. It's a goddamn farce. It is illegal.
Right. And look, even if the government were right about all of that, even if Christian were a member of TDA, and even if his asylum claims would be rejected, that doesn't mean it's like a get out of jail free card for due process. There is no harmless error exception to due process, right? The argument is like, we would have wound up deporting this guy anyway. That's not the law, right? It's not something we would accept in any other context. If the cops beat a confession out of you and you really did commit the crime, the courts don't like shrug and say, it all washes out in the end, so let's use that confession that you got when you like beat that guy about the head and, threatened to lock up his mother.
Yeah. And on top of all of that, you don't get to lock this guy up in a gulag indefinitely. Right? Like if he was liable to be deported, then deport him. But confinement without charge or sentence is I'm running out of synonyms for lawless.
Yeah. So as you can infer, Judge Gallagher denied the government's motion and stayed her order for 1 day to let the government file an appeal, which it now has to the Fourth Circuit, which, as you can remember, was not super friendly when the government tried this with Abrego Garcia.
Yeah, but two things. So first, the government's appeal was also filed under seal. That could be lifted, but as of right now, we can only see the notice that it has been filed. We cannot see the merits of the argument. And right before we went to record, the Fourth Circuit administratively stayed Judge Gallagher's order until next Thursday, May the 15th, and then set expedited briefing. So the plaintiff's opposition is due by noon on Monday, May the 12th, and the government's reply is due, 21 hours after that, before 9 a.m. the next day, Tuesday, May the 13th. And, there's always sort of the boilerplate language that says an administrative stay is not indicative of how the panel views the merits. I tend to believe that here.
Right. I believe the Fourth Circuit stayed the Abrego Garcia case for a few days before coming back and saying, send this guy back, stop being crazy.
Okay. And we will continue to talk about immigration when we return after this brief ad break, unless, of course, you are a subscriber over at patreon.com/lawandchaospod or on Substack at lawandchaospod.com, at which point no ads for you ever.
And we are back. Okay, while we were talking about immigration, we now have a third U.S. District Court judge who has weighed in on the legality of President Trump's proclamation under the Alien Enemies Act. And it's another old bull who will not be pushed around. This time it's Judge Alvin Hellerstein. He is a 91-year-old Clinton appointee who sits in the Southern District of New York. He's not Trump's favorite judge. He's the one who keeps saying Trump has tried, remember, there was the state prosecution that Manhattan District Attorney Albert Bragg brought against, the 43 criminal counts, whatever it was. So Trump tried multiple times to get that case moved to federal court because that way you could get it dismissed. And multiple times Judge Hellerstein was like, no, paying off, the porn star payoff was not part of your official duties. Get back to the city, you weirdo.
That's right. And for our purposes today, like Judge Rodriguez in Texas and Judge Sweeney in Colorado, Judge Hellerstein concluded that the statutory prerequisites for a president to invoke the Alien Enemies Act have not objectively been satisfied. So he cannot do it. Look, we are not at war with Venezuela. Members of the Venezuelan gang Tren de Aragua are not soldiers. Judge Hellerstein's opinion also raises a really interesting interpretation of what due process would be required under the Alien Enemies Act if it did apply. It's not an argument that we've seen before. Unfortunately, I think he's probably wrong on the law, so we're going to talk more about that in the subscriber bonus and geek out a little bit. But look, that part that I think he got wrong of Judge Hellerstein's opinion applies only if the Alien Enemies Act is properly invoked. And I don't want us to lose sight of the primary holding, which is, no, it was not. It is not applicable.
Yeah, this is a stem winder. It begins by quoting the Declaration of Independence, that we're all created equal and endowed with inalienable rights. And then it goes on to say, to call out the administration in really clear terms for its attempt to gut due process, to get around the constitutional guarantee of due process for everyone, citizen or not. He says, drafting complaints with particular allegations against individual aliens, providing aliens with time to contact counsel and file a habeas petition, and preparing for a hearing before a federal judge takes time and manpower. However, it is the nature of due process to cause fiscal and administrative burdens. Rule by the ipsy-dixit of a president is likely more efficient than the deliberative procedures of a court, but it is what our Constitution and the rule of law demand, and due process, once surrendered, is difficult to reinstate.
And I can't help but compare that to the Tucker Act decisions we talked about before the break, right? Which are like, look, if the government can't fire people immediately and withhold funds, then that's irreparable harm. No, right? This government was never meant to function at, maximum efficiency and minimum fairness. It was meant to be the other way around.
Absolutely. So Judge Hellerstein's opinion proceeds in three parts. First, he explains that, yes, the court has the power to judge whether or not the Alien Enemies Act was properly invoked or not. And then second, he works through the statutory prerequisites to determine that, no, it was not properly invoked here. And third, he breaks down what sort of due process these alien enemies supposedly are entitled to.
Yeah. So let's begin with the Alien Enemies Act is a terrible law. Like we have talked about this before, but this was passed in 1798 during one of the most xenophobic and terrified moments in early American history, right? When the nascent country really thought it was about to go to war with France, a global superpower. And so Congress did all sorts of awful and scared and in some cases blatantly unconstitutional shit that fell under the rubric of today, what we call the Alien and Sedition Acts, right? So the Sedition Act made it a crime for American citizens to, quote, print, utter, or publish any false, scandalous, and malicious writing about the government, which you will recognize as 100% violating the First Amendment, right? And one of the Alien and Sedition Acts was the Alien Enemies Act, which authorizes the president during wartime to round up citizens of an enemy nation and arrest, imprison, and or deport them. This is a terrible law, and it shouldn't be on the books. It is the sort of thing that, you and I learned as school kids as a low point in our nation's history and, middle school history and from Schoolhouse Rock. But even though the Alien Enemies Act does in fact provide the president with broad powers of removal, the very first sentence of that law says that it can only be invoked in one of two instances. The first is if there is a declared war between the United States and any foreign nation or government.
And that's something that's not open to interpretation. Only Congress has the power in Article 1 of the Constitution to declare war. It's literally a resolution that either passes the Congress or not. And Congress has not declared war, so no, that's a no on that box. So what the Trump administration has done is tried to fudge the second set of conditions, which says if any invasion or predatory incursion is perpetrated, attempted, or threatened against the territory of the United States by any foreign nation or government. So in the absence of a declared war, the administration has to show that there's been an invasion or predatory incursion into the United States by a foreign nation or government. And the question from a legal perspective is whether the president gets to just say those three things exist and will them by executive fiat into reality, or whether a court can look at the actual facts on the ground to see if we are under invasion or predatory incursion.
Right. And as we know, Trump has asserted the former. So on March 15th, the White House issued that proclamation. They said, just conclusory, Tren de Aragua is perpetuating, attempting, and threatening an invasion or predatory incursion against the territory of the United States. It isn't. And that it is doing so, quote, directly and at the direction, clandestine or otherwise, of the Maduro regime in Venezuela. And that's just not true.
And in fact, the intelligence community has said it's not true in a memo which was first leaked and then released pursuant to a FOIA application, right? The FBI said it was getting a little bit of chatter that said some, detainees had gotten marching orders from some government officials, but they said it was ridiculous. First of all, they said that information lacked indicia of credibility. And second of all, they said it just wasn't accurate, that many members of Tren de Aragua had been locked up by the government, by the Maduro government in Venezuela, and that, it just wasn't real, right? That was the widespread conclusion. And then Tulsi Gabbard threatened to lock up anybody who would say, the deep staters who are trying to undermine the administration, because she would.
Yeah, well, in court, the Trump administration has argued it doesn't matter whether it's true or not because they contend that the president's power under the Alien Enemies Act is plenary. That would mean that no court has the authority to evaluate that determination to see if it is true or false. And okay, that seems medium to hot crazy, right? It's actually not, sorry, I'm thinking about cooking. It's actually not the worst legal argument that the Trump administration has made in court. Bear with me on this for a minute. It's still bad. But there are two reasons why you could make it and, not be subject to sanctions, right? So first, there are some presidential powers that are plenary, right? Like pardons, for example. Donald Trump can say, Michael Flynn is a patriot who never lied to the government and was persecuted by evil Democrat Robert Mueller, so I'm pardoning him for the good of America. And every word of that is a lie, right? But it doesn't matter. He gets to pardon him, right? And second, we've talked about this before. There is one case from the Supreme Court interpreting the Alien Enemies Act. It's called Ludicky versus Watkins. It's from 1948. And in that case, the Supreme Court deferred to the executive branch, saying that World War II hadn't ended in 1946, even though, objectively, it ended in 1945.
Right. So far, no court has adopted that argument. The most the Supreme Court said in its administrative stay in the JGG case is that the Alien Enemies Act largely precludes judicial review. Lower courts have said, okay, largely, but our job is to make sure that statutes are interpreted properly. And like Judge Hellerstein, those judges cited to Marbury v. Madison, which is the landmark 1803 Supreme Court case, which invented, for lack of a better word, the power of judicial review. So while the Alien Enemies Act gives the president a lot of power, judges can still intervene at step one and see if the statute was properly invoked or not, because that's what courts do. That's their IRL job.
Yeah. There's a second argument here that Judge Hellerstein and Judge Rodriguez both made, and I think it's really clever, and we're going to get into it after this brief ad break. And we're back. Okay, here's the gambit. And Judge Hellerstein isn't the first district court judge to throw this elbow. This is a citation to the Supreme Court's 2024 decision, Loper Bright Enterprises versus Raimondo. And if that case sounds familiar, it's because Liz and I have talked about Loper Bright on this show a lot. That was the case in which Chief Justice Roberts finally delivered to the right wing what they have wanted, gleefully overturning the doctrine of Chevron deference that said the court should listen to administrative agencies when those agencies determine what an ambiguous statute means. So in Loper Bright, the conservative Supreme Court said, look, we don't have to defer to those executive branch agencies anymore when they tell us what a law means, because only courts can, quote, decide questions of law. And then Chief Justice Roberts goes on to say that there is only one objectively right interpretation of any law, and that the courts, his words, must exercise their independent judgment in determining the meaning of statutory provisions.
So now we have Supreme Court justices, or even like trial judges, appointing themselves like food safety experts and medical experts. Like, it's so ridiculous for the courts to say only we know how to interpret a statute, and the executive branch doesn't know anything. All of those agency experts, screw those guys. We're the ones who know.
And anybody who's ever been to law school, right? Like you learn legal realism on like day 2 of con law, right? Like nobody has thought for a century in this country that like laws mean one platonic ideal, right? Like that's nuts. But Judge Hellerstein is thinking, okay, if that's the law, if that's what you guys said statutes mean, then that seems to imply that courts also have an independent duty to determine if the Alien Enemies Act was properly invoked, right? Like, courts can't defer to the president just saying a thing any more than they could defer to the Department of Education or any other executive branch agency, right? Like, there's only one right meaning to any law, and we get to say what it is. And that means that it is completely irrelevant if the president says an invasion or predatory incursion into the U.S. exists. That's a legal question. So what, right? The question is it true? And Loper Bright does seem to suggest that courts always get to decide if a statute has been properly invoked, and they do not have to listen to the executive branch at all.
Yeah. Okay, so once Judge Hellerstein determined that courts and not presidents get to decide whether there's a predatory incursion, he moved to the second part of his opinion, and he said, well, no, there is no incursion, which no shit, of course there's no incursion. So Judge Hellerstein was pretty cognizant that this issue would ultimately wind up on the desk of the Supreme Court. So he used the tools of originalism, or as it is currently understood by the goons on the Supreme Court, who are constantly like, I've pulled out a dictionary from, 1802, and it says like some totally anachronistic definition of the word, and that's what the law meant at the time. So, you lose and everybody gets to walk around with an Uzi. So Judge Hellerstein was like, fine, you want to play this dumbass game? Fine. Let's construe the meaning of the terms invasion or predatory incursion as they would have been understood at the time the Alien Enemies Act was enacted in 1798. So he looked at various 18th century dictionaries, noting that all of these definitions contemplated an invading army, which we do not have.
Yeah. Same thing for incursion in the 18th century. That word was only used in one of two ways, right? Either to mean an unsuccessful invasion, which makes sense, or to apply to, quote, military-like conflicts waged by an Indian tribe or a foreign nation state, as opposed to civil immigration violations. So in other words, what he says is, even if Tren de Aragua was as bad as the administration says it is, and it is not, right? Like that is just not consistent, as you pointed out, Liz, with our intelligence agencies. It doesn't matter, right? There is a difference in kind between even mass criminal behavior and war, invasion, or predatory incursion of the United States. And that has been the conclusion of every court to look at this on the merits.
Yeah. So having agreed that we're not under incursion or invasion or whatever, however that would have been understood in 1798, that's kind of the end of the inquiry because there has never been an appropriate invocation. So he's basically saying that invocation is a nullity. But he doesn't stop there. Judge Hellerstein goes on to touch briefly on an issue of how the Alien Enemies Act is applied and what process is due to those who are subject to the Alien Enemies Act under a proper invocation. And that's the part, Andrew, that you think is not going to survive on appeal to the Second Circuit?
I don't. I do think it is very, very clever, right? Like this got our attention when we read Judge Hellerstein's order.
Right. It's one of those things like, wow, wait, there was a whole interpretation of like there's more to this statute and nobody ever talked about it. I'm not going to say it's one weird tricky, but it was certainly like, whoa, how did nobody else know about this?
Yeah, how did we miss this? Is what we said to us. So Judge Hellerstein is of the view that even if the Alien Enemies Act does apply, the executive must file as a complaint before an Article III court against any alien that it wants to deport under the AEA. And he cites to 50 U.S.C. Section 23, that the Alien Enemies Act begins at Section 21. And if he is right, this would be a fantastic result, right? It would give detainees significantly more process than the government is currently providing, and even more than what the Supreme Court and other district court judges have said that they're due. Because under Section 23, when that complaint is filed, the reviewing court must conduct a full examination and hearing and then determine if sufficient cause exists to remove the subject, which that sounds great. But in the subscriber bonus, we're going to get into all the law geekery about why I am not convinced that Judge Hellerstein has it exactly right.
Right. But if you're not a subscriber, you should become one. But if you're not a subscriber, I just want to not leave you with the impression that we think that Judge Hellerstein's entire order is going to fall apart because, as he said, the step one is, was there a valid and appropriate invocation of the Alien Enemies Act? And if you conclude that there wasn't, all the rest of this stuff about what process is due to alien enemies under the act is moot, right? It's moot. If the act wasn't properly invoked, then that's the end of the inquiry. The rest of it is just interesting padding.
Yeah, it's really going to be deep dive geekery in the subscriber bonus, which, again.
I know you guys love that. Okay, if you're a subscriber, stick around for that part. If not, we'll see you on the other side of this ad break. We have good news out of the state of Alabama from our favorite federal judge in the state, Judge Anna Manasco. Hang on, we'll be right back, you guys. And we are back. Okay, let us end the show with some more good news. We're going to talk about a voting rights ruling out of Alabama in a case we've been covering forever called Milligan v. Allen.
Yeah, you are not kidding. You and I have been talking about this case for years. And the reason we keep talking about it is that since 2021, after the 2020 census, the state of Alabama just keeps enacting these same racist congressional maps and hoping that, maybe this time the Supreme Court will let them get away with it. Or, as Judge Anna Manasco put it, the legislature's conduct thrusts this case into an unusual posture. We are not aware of any other case in which a state legislature, faced with a federal court order declaring that its electoral plan unlawfully dilutes minority votes and requiring a remedial plan that provides an additional opportunity district, responded with a plan that the state concedes does not provide that district. End of actual quote. This case has been up to the Supreme Court twice, and both times Chief Justice Roberts and Justice Kavanaugh sided with the court's liberals to say, no, Alabama, you are clearly drafting these maps to dilute black voting power, and that violates the law. So here's the issue. Alabama got an additional congressional district after the 2020 census, so now they have 7. Alabama is 27% black. The undisputed evidence from the record is that white voters in Alabama vote as a supermajority bloc for white candidates. So courts have now, by my count on at least 3 different occasions, told Alabama to redraw its congressional map to have at least 2 black opportunity congressional districts. And every time, the state legislature just keeps coming back with a map that packs all of the black voters in the state pretty much into 1 black opportunity district. And so, if you're doing the math, 1 out of 7 congressional seats is 14%. 2 out of 7 would be 28%, or almost exactly equal to the percentage of black people in the state. This seems not hard to grasp, but also Alabama's Governor Kay Ivey is super racist.
Yeah, I'm not going to speak to what's in that woman's heart. I will say that she couldn't do it by herself, right? This is what the legislature keeps enacting.
True.
So this case is important on a bunch of different balances. The reason that Alabama keeps trying it, aside from general cussedness, is that conservative activists hope to use the state's redistricting lawsuits as a vehicle to destroy what's left of the Voting Rights Act of 1965. Specifically, Section 2, which says that you don't have to prove racist intent to challenge a legislative district. You just have to prove that the effect of the map is to dilute minority voting power. And the test for that was articulated in a case called Thornburg v. Jingles. It's called the Jingles test. So to prove racial dilution, you have to show that the minority group in question is sufficiently large and geographically compact to constitute a political district. Okay, so you can't just say you can't do it as a percentage, right? If the population is evenly distributed, you don't have to draw a map to make sure that 28% of the seats are black, because there's to reflect the population of the district. Okay. The second thing you have to show is that the minority group is politically cohesive, meaning that they generally vote for similar candidates. And the majority group is also politically cohesive and will vote to defeat the preferred candidates of the minority group. And as you said, Andrew, in the intro, there's ample evidence that white voters in the state of Alabama vote as a bloc. And if you do not draw the districts to accommodate that, then white voters will always outvote the black candidate, or the candidate preferred by the minority voters. Right. So the first time around, Alabama was like, hey, SCOTUS, how about you toss out Section 2 and get rid of the Jingles test? And the Supreme Court said no. Although, if I recall correctly, Kavanaugh said in a concurrence, maybe we've done such a great job eradicating racism in this country that we don't need Section 2 anymore. Not now, not for this, but soon, question mark?
Kavanaugh taking a break from, as we usually know him, writing concurrences with wildly right-wing opinions, explaining how, really, we're not so bad. We're not monsters. It's just that 1734 dictionaries compel this result. This time, he's writing a concurrence to imply that conservatives shouldn't give up hope, which, I think part of the reason that the state of Alabama went back and came up with another 6-1 congressional district map was because of Kavanaugh's dumb concurrence.
Right. So the second go around, the Supreme Court rejected the cert petition. And now we're back here again because for a third time, the state produced these defective racist maps. So the judges on the 3-judge panel, 2 of whom are Trump appointees, are righteously pissed. They've told these guys, fix your shit. And, they haven't fixed it. And we're always here for a good bench slap. But in addition to that, the plaintiffs here are now asking for Alabama to be bailed in to the preclearance requirement for future redistricting under Section 3C of the VRA. And the court says, we're going to entertain arguments on that, which is, that's a really interesting development.
Yeah, this one requires a little bit of unpacking, right? So when the Voting Rights Act was passed in 1965, Section 4B of the Act said that states and jurisdictions, counties, congressional districts within the states, with a history of discrimination in voting rights, cough, cough, required what was called pre-clearance from either the Department of Justice or a 3-judge panel of the United States District Court for the District of Columbia before those states or jurisdictions could change their voting laws or practices, right? And it's not hard to see why, right? It was like, hey, if you do this without supervision, you're going to do it in such a way as to disenfranchise minorities. So you got to come back to us and ask for permission before you change your laws or your practices. And there was this coverage formula in Section 4B that let the government figure out which states, which jurisdictions needed pre-clearance. And then in 2013, the Roberts Court struck down that coverage formula in an infamous case called Shelby County versus Holder because, we solved racism in 2008.
Thanks, Chief Justice Roberts.
Yeah. As a result of Shelby County v. Holder striking down that statutory preclearance, litigants were forced to adjust, and they had to go to a less good provision of the Voting Rights Act. It was once called the obscure provision. It's Section 3C that you mentioned. So under 3C, you can go to a court and get a specific determination that a state or political subdivision has engaged in historic discrimination, right? It doesn't use the math. It says a court conducts some fact-finding and comes to this conclusion. And then under 3C, that court can craft limited preclearance for a limited period of time that the court deems appropriate until the covered state or subdivision, gets its act together. So that's why it's called the bail-in provision. It is far less comprehensive than the statutory 4B preclearance that got, nuked from orbit by the Roberts Court. So, as with everything since the early 2000s, something's better than nothing, I guess, right? So during the period, if a court determines that 3C preclearance applies, then that state or political subdivision cannot make any change to its specified voting laws or practices until that court determines that the change has neither the purpose nor will have the effect of denying or abridging the right to vote based on race, color, or language minority status. And case law has made it clear that relief needs to be targeted and limited in duration. So look, there's not a lot of case law on Section 3C, but the act of just evaluating Alabama is a pretty monumentous decision, right? Like this court is going to have to decide whether constitutional violations in the state have been persistent and repeated. They have to decide the probability that they will recur in the future. And then they have to decide whether preclearance, imposing this 3C preclearance, is going to solve or combat or reduce that problem. And, given Alabama's recent history since 2021 that you've described, Liz, I don't think the fact-finding is going to go great for it.
Yeah, I mean, I would agree with you on all of that, except that, look, I think part of the reason that Alabama is getting hit so hard by, you've got 2 Trump appointees on this panel, although as we, Judge Anna Manaska, Judge Stephanie Gallagher is not somebody who would get appointed by Trump now because she's not a raving lunatic. Okay, but I think that the Supreme Court is not really so hot on the VRA, and part of the reason that the Supreme Court has been hard on the state of Alabama is that Alabama has been so wholly defiant of judges. Mm-hmm. So this is like a do we believe in the rule of law question? And the answer is mostly when it comes to the Supreme Court. But reinstituting the preclearance requirement would be like, do we believe in voting rights? And with this Supreme Court, the answer is resounding hell no. So I do think it's interesting. And I continue to be amazed that Alabama keeps trying this shit, but I wouldn't hold my breath on that one.
I think you're right to temper enthusiasm, but I remain, that look, we're ending on some good news, and
yes.
How often do we get to do that?
All right, then I think we should say good night, Gracie. Thank you guys so very much. I hope you have a lovely weekend. I enjoy the spring day. And we will see you back on Monday with written content and Tuesday with another podcast. If you enjoy the show, please, please, please like us and leave us a nice review on your podcast platform of choice. Have a wonderful weekend.
Law and Chaos Podcast is a production of Raise Up Media, LLC, is intended solely as entertainment, does not constitute legal advice, and does not form an attorney-client relationship. This show is researched and written by Liz Dye and produced by Bryce Blankenagel. Law and Chaos Pod, copyright Raise Up Media, LLC, all rights reserved.